Hello, guys. I hope you're all live. Let me see. Let's see how many people we have on board. You have a good few people here. Let's give everyone a bit to join in. Hello, Tanya. Hello, Shubhi. Good to know some of our internal students are here. We have been looking forward to you all. I'll be keeping an eye on the chat. I am sharing the screen now. Let's wait a couple more minutes. A very good evening, Shubham. Hope you're all excited. All right. We have 17 people. Hello, Ravi. Hello, Vaishnavi. All right, guys, it's 7:04 and we don't have long. This is Delhi Judiciary after all, so we must be on time. Let's be punctual. Let's put in the best effort in time, in studying, preparation, and in executing everything. So, guys, welcome. I find you all to be the torchbearers of tomorrow's torchbearers of justice. So, I hope you're preparing well and you're giving it your all. Let's walk through this mental jog on the most pressing prelims questions. This is your first quiz, a series of quizzes that we have curated in our DJS series of prelims. And we will be preparing you all around, whether it's your mocks, your quick recapitulating marathons, or these your quizzes. This is first of many. You shall have access to many quizzes all throughout. Vikas, please let me know if at any point there is an issue in the audio or the video or anything. Or the students, you can as well let me know in the chat. I'm keeping an eye on that. So this is your constitutional law quiz. We'll be presenting it through a presentation on the screen, as you can see. What this will work with is there will be a question, then a quick 5-second timer, and within which you have to type down your answers. That is how you participate, Jasmine. I present the question on the screen. You participate by answering your best guess in the comments, and then I reveal the answer. What I would encourage you to do right now is to keep a pen and paper right by your side so that you jot down anything that you feel like you're not doing well in. And for those of us who are competitive, this is DJS, so I hope we are all competitive. You can keep a tally on how many questions you are getting right. Easy to do. Just keep a quick tally on the side of your paper. So, are we ready? Should I start with the first question? Come on, let's see some gusto, some energy. Let's see how you are doing with constitutional law. I don't see any energy in the comments. Are we ready? Jasmine, Muskan, Shubham? Excellent. Okay, Pritika has joined us as well. So here we go, guys. This is our very first question. Which article of the Constitution of India guarantees citizens the right to settle in any part of the territory of India? Is it 19(1)(a)? Is it 19(1)(d)? Is it 19(1)(e)? Or is it 19(1)(g)? You can type in your answer now. You have 5 seconds that has started. You're thinking it's 19(1)(e). And the correct answer is 19(1)(e). Excellent. Well done, Jasmine, George, Pritika, Shubham. Okay, excellent. Good start. We all know what it is. The right to reside and settle in any part of the territory of India is given under Article 19(1)(e). Let's go through it quick. This should be rapid. Second question. If an amendment to the first schedule of the Constitution is made to change the name of a state, then the procedure required is which one of these? 1. Two-thirds majority in both houses of parliament. 2. Two-thirds majority in both houses and ratification by not less than half of the states. 3. Simple majority of both the houses of parliament. 4. Simple majority in both houses and ratification by not less than half of the states. Your timer starts now. Okay, some of us think it is simple majority of both houses of parliament. And okay, I see uniform questions coming in. Only with Jasmine, there's an answer of D, I think. The correct answer is simple majority by both the houses of the parliament. Quick thing to remember, this requires changing the name of the state requires, we have articles 3 and 4 for this, the parliamentary approval method. What it requires is that the president sends a bill that, hey, to the state, the name of your state is required to be changed. Let's take into account your views. The state assembly is involved. Then, as you can see, this is when the state assembly expresses its opinion, then the thing is introduced by the recommendation of the president into the Parliament of India. And if the Parliament wills, the bill is passed by simple majority in Parliament, and then it goes back to the president for approval and it becomes an act, and thus the thing is changed. A very important thing and interesting fact is that these things, admissions of establishment of new states, formation of new states, alteration of boundaries, names, etc., no matter what, if they change, they are not considered to be amendments of the Constitution for the purpose of Article 368. So if this happens, that does not qualify as an amendment of the Constitution. Next question. The right to audience under the Indian Constitution, which is given to the Attorney General of India in the performance of his or her duties, is the right relating to which of these? 1. Is it for his appearance in courts? 2. Is it for appearance before the House of Parliament? 3. Is it for appearance before the Cabinet for legal issues? Or 4. Is it the appearance before the President of India? Answer now. Pritika thinks it's 1, appearance in courts. Shubham thinks it's 2. 3. We are getting very diverse answers. Most people think it's 2. All right. Come on, some more of us. What is it? Tanya thinks it's 1. It is 1 appearance in courts. Important. Article 76(3) tells us that while the Attorney General is performing his functions, one of his functions, his duties, for the performance of his duties, he has a right to be an audience in all courts in the territory of India. So the right to audience is him being part of the audience in the courts in the territory of India. Next question. In Shreya Singhal versus Union of India 2015, the Supreme Court struck down Section 66A of the Information Technology Act 2000. For which purpose and how? Option 1. In its entirety for violating 19(1)(a) and not being saved by 19(2). 2. In its entirety for violating Article 14 and Article 21. 3. Partially, it was struck down, but read down the scope of the provision to bring it in conformity with Article 19(1)(a) and 19(2). Or 4. Partially struck it down, but read down the concept, read down the scope of the provision to bring it in conformity with Article 14 and 21. Questions coming in that soon. Excellent. You don't even wait for the timer. Very good, Girija, Anuradh. Very good. Okay, most of us think that is it, and that is correct. It was struck down. 66A was struck down for its entirety because it was stated that it violates 19(1)(a) and it is not being saved by 19(2). And this is the exact snapshot of what the Supreme Court wrote down via Justice Nariman in this case. And it stated that the 66A section of the IT Act is struck down its entirety and not saved by 19(2). This is in para 119 of the judgment. Next question. It is DPSP to promote international peace and to maintain just and honorable relations between nations and to foster respect for international law, treaties, and obligations. It is a DPSP, that is a fact. Now, for this purpose, 1. Will the DPSPs override national legislation where the matter is subject to international treaties and law? 2. Or will the DPSPs have to be incorporated into legal systems by appropriate law? Or three, will they override the provisions of the Constitution of India? Or four, will international treaties are they automatically assumed to be part of India? Your timer starts now. What do you think? What is the purpose here? What is the application of DPSPs here? Someone says A. Tanya thinks 2. It is 2. Tanya, Divraj, Muskan, Talin. Talin is here. Excellent, Talin. Shubhi, Komal. It is 2. The DPSPs have to be incorporated. It is a key thing to remember, no matter what. See, the DPSPs are important, right? But they do not have the same legal obligation and the same legal emphasis and gravity of fundamental rights. Even when you look at, you might be confused and thrown off by 31A, Article 31C. But even if you look behind it, the saving of Article 31C says that notwithstanding anything contained in Article 30, no law giving effect to the policy of the state towards, no law giving effect to the DPSPs, right? Essentially, that means the law has to begin. There has to be a law to begin with, right? So even in 31C, if you feel like 31C is enhancing the importance of DPSPs, yes, it did do that. But then even for the enhancement of DPSPs, there has to be a law which enforces these DPSPs. So no matter what, the DPSPs have to be appropriately translated into the law of the land. Next question. In the Hadia case, important. In the Hadia case, the Supreme Court held that the right to marry a person of one's own choice is integral to which of the following? Options 1, Article 19, 2, 14, 3, 25, and 4, 21. Timer starting now. What could be the correct answer? Komal thinks it's 21. Diviraj thinks it's 21. All right, and mostly everyone is correct. Talin, no, it's not 3, it's 4, Article 21. Okay, Hadia case, an important case where the parents of the girl were forcing the court to see the perspective that it was a case of love jihad. There was a forced transition. There was a forced transition of religion. It was popularly known as the Hadia case. It battled the social human cry of love jihad in India. And within this case, the court stated it cited Article 16 of the UDHR, the Universal Declaration on Human Rights, and it emphasizes marriage as an important incident of human liberty. So, emphasizing that, the court read the right to marry into Article 21 of our Constitution and said that the right to life is inclusive of the right to marry a person of one's choice. Next question. The Supreme Court held, this is a key case, we should all remember this, I'm hoping everyone knows this. The Supreme Court held that the election commissioners cannot be placed on par with the chief election commissioner in terms of power and authority in which of the following cases? Was it the case of S.S. Dhanwa versus Union of India? Was it T.N. Seshan? Was it A.C. Jose? Was it Venkatachalam? Which case was it? Time is starting now. People think it's T.N. Seshan. Shubham thinks it's S.S. Dhanwa. And it was S.S. Dhanwa. All right, guys. It was S.S. Dhanwa versus Union of India. In this case, Justice P. Sawant wrote that the appointment of both the Chief Election Commissioner and other election commissioners as it stands today is made by the President. But when there are two different bodies, a multi-member body commission is written down. It means that they do not always need to be on par with each other. If it is a multi-member body, the functions are different. They're not on par with each other. Their rights, their duties, the obligations cannot be read to be the same. S.S. Dhanwa is the correct answer to this question. Next, which provision of the Constitution empowers the Supreme Court to form 9 judge benches? 9 judge benches. How is the Supreme Court empowered to do this? Is it Article 145? 2? Is it Article 1453? Is it Article 1454? Or is it Article 1455? We know it is 145, but which portion of 145? Time is starting now. What do you guys think? Come on. I need more guesses. Let's be more proactive. We need more guesses in the comments. And the correct answer is 1453. 1453, while it does not write down that 9 should be the number or 7 should be the number, it states a basic limit, a basic limit, a minimum number of judges for the constitutional benches, which is 5. So there is no mandate on the upper limit, but it is stated that it should be an odd number. So it can be 5, then it can be 7 and 9. And we know why it should be an odd number, so that the decision can go in one favor and there is not an equitable split between the decisions. Next, someone answered 5. Okay, you meant the option. Okay, 1435, 1455. Next question. The pardoning power given to the President of India under 72, Article 72 of the Constitution of India, can be exercised when? Is it after the trial and on conviction and award of sentence? Or is it during or after the trial, but never before the trial? Or is it at any time, whether during or after the trial? Or is it either before or after the trial, but never during the trial of the case? Which of the following is it? When can the pardoning power be exercised? Okay. Everyone thinks it's 1, and everyone over here is correct. Excellent. Everyone got it right. Amazing. It is after the trial, because only when the trial is done, the conviction is done, the sentence is awarded, only then can we move forward to the president with the pardoning letter, and then can Article 72 take effect. Next question. Question 10, this is, the law which violates fundamental rights is overshadowed by the fundamental rights and remains dormant, but it is not dead. What doctrine does this statement relate to? Is it the doctrine of severability? Is it the doctrine of harmonious construction? Is it the doctrine of retrospective effect? Or is it the doctrine of eclipse? Some of us think it's severability, some of us think it is eclipse. All right, and this is before the timer even starts. Amazing work. Most of us thinks it. Oh, excellent. Most of us here are getting it right. This is the doctrine of eclipse, based on the principle that a law which violates something is not void ab initio. It is not a nullity in its entire state where it becomes unenforceable. It is eclipsed by the power, by the weight of the fundamental rights. And this doctrine emanates directly from 13.1 of the Constitution, which in itself also is a part of the fundamental rights. Next question is, who among the following has the power to investigate the charges against the president during impeachment processes? Impeachment proceedings. Is it 1, a committee of members which are constituted by the houses of the parliament? Is it 2, it can be either house of the parliament? Is it 3, that it has to be both the houses of the parliament jointly? Or is it 4, that it has to be a committee that is headed by the chief justice? Come on, answers coming in. We didn't see answers coming in here. 4, a committee headed by the chief justice. Shivani thinks it's 1. And the correct answer is either house of the parliament. Article 61.3, guys, either house of the parliament. No one guessed. Divyaraj guessed right. Shubhi guessed right. Komal. All right. So 61.3 states that when a charge has been preferred by either house of the parliament, that is the house of parliament, either house of parliament is preferring a charge, right? So that is 61.3. And then the other house investigates it or causes it to be investigated. And then the president has the right to appear and to be represented at such a investigation state. Next question. The power of judicial review is vested in the Supreme Court and High Courts respectively by 32 and 226 of the Constitution. And it in itself is a not a part of the basic structure of the Constitution. 2, a part of the basic structure of Constitution. 3, not a part of the basic structure but a statutory right. Or 4, not a part of the basic structure of the Constitution but a constitutional principle. Which one of these is it? The timer is starting now. We think it is not. It is a part. It is a part. It is a part of the. All right. And there we go. It is a part of the basic structure of the Constitution. Someone thinks 1 and 3. No, it is a part. We refer to the case of L. Chandra versus Union of India, the appeal case. The Supreme Court has ruled that the power of judicial review vested with the Supreme Court and High Courts respectively, they are a part of the basic structure of the Constitution. So these functions cannot be touched by amendments. Next question. Which of the following cases paved the way for compensatory jurisdiction of the Supreme Court by being first of its kind decision? So a first of its kind decision which opened the gateways for compensatory jurisdiction. Was it the case of Rudul Shah versus State of Bihar? Was it Chiranjit Lal Chaudhary versus Union of India? Was it Keshav Madam Menon versus State of Bombay? Or was it P. Rathinam versus Union of India? Jasmine thinks it's Rudul. Arjun thinks it's Chiranjit. All right, the timer has started upon all of us. Let's all answer. Let us all answer here. The correct answer is Rudol Shah, of course. In this case, we remember the petitioner was kept in jail 14 years, even after he was acquitted, and the court stated that the right to compensation is some palliative for the unlawful act. So it is a remedy in a sort, right? For the failure of the court to protect the person as a shield. So the petitioner's detention in the prison was held to be wholly unjustified, and he was allowed this compensatory justice. Next question. In which of the following cases was it stated as a right of the prisoner, guys, that an arrested person or an under trial prisoner, again, right of a prisoner, arrested person, under trial prisoner, should not be subjected to handcuffing? Was it the case of Sunil Gupta versus State of Madhya Pradesh? Was it Sunil Batra versus Delhi administration? Was it Stanislaus versus State of Madhya Pradesh? Or was it the case of TMA Pai Foundation versus the State of Karnataka? Your timer is starting now. We have guesses coming in. Sunil Batra, Sunil Batra, Sunil Batra. Excellent. So you were not thrown off. Sunil Batra versus Delhi administration. Yes, that is the correct answer. And the Supreme Court held here that the fetters, they are a violation of human dignity within and without prisons, whether within prisons or without outside of prisons. It is indiscriminate to resort to this. Reckless handcuffing should not be done. Chaining in public, it degrades people, and it is a slur on our culture and a slur on dignity. So it was shunned, it was shunned down, it was looked down upon. Next question, question number 15. We have 100 questions to go through. This is rapid. Let's keep up. Which of the following provides for the adjudication of any dispute or complaint within respect to the use, distribution, or control of the waters of or in any interstate river or river valley? So which of the following bodies provides for the adjudication of any dispute if any dispute arises? Is it the Supreme Court, the High Court, the Parliament, or is it done by a committee that is formulated by the Supreme Court? Excellent. This is how I want things to be. Answers coming in before the timer even begins. So let's beat the timer. It is the Parliament. Yes. Someone answered Supreme Court or something. No, it is 3, Parliament. Parliament is empowered by Article 262(1) that the Parliament may by law provide for the adjudication of all these issues that we highlighted in the question. It is Parliament. Komal, Muskan. Let's go back and revise 262(1). Next question. Who can call joint session of the two houses of the Parliament? Okay, Komal, I want you to answer this and answer it right. Speaker of the Lok Sabha, Vice President, President, or none of the above? A joint session of the two houses of the Parliament. Who can do it? A joint session. Guess is coming in, and it is the President. Excellent, Komal. Well done. The President, as per Article 108, can call the joint house meeting, joint session meeting. Now, this is of bills other than money bills. Next question. I'm giving you quick cues and clues within it, just little morsels of extra information. Next question is: the president, under his judicial power, is empowered to pardon offenders or do what to their sentences? Does he only remit and reprieve their sentences? Does he remit, reprieve, commute their sentences? 3, does he remit, reprieve, suspend, or commute their sentences? Or does he have the power to do none of these? Time is starting now. Some of us think it's remit, reprieve, or commute only. Some of us think it's remit, reprieve, suspend, or commute. And the correct answer is all 4. The president has, under Article 72 of the Constitution, the power to do any of these things. He can suspend, he can remit, he can commute, right? And he can even reprieve. Next question. The residuary powers of the Parliament given under which article of the Constitution? Where do they reside in the Constitution? Are they in Article 115? Are they in 248? Are they in 369? Or are they in 240? Residuary powers of the Parliament. Come on, guys. Where are they? We think it's 248. That is correct. Excellent. Very good. 248. So many comments coming in. Let's keep it going, guys. 248 has the residuary powers of the Parliament, giving the exclusive power to the Parliament to make laws in respect to any matter that is not within the concurrent or state list. So that is left out. Next question. Equal justice and free legal aid are provided for in which article of the Constitution of India? Article 38, 39A, 27, or 22A. A quick timer start. Answers coming in. Which article? 39A, 39A. And we are correct. It is 39A indeed. Important, where was it added into the Constitution? Via the 42nd Amendment. These ideals were added into the Constitution. Next question. Amazing pace we have here. The tenure of a governor ends at. Important for your understanding. The tenure of a governor ends when? Does it end after 5 years of service as a governor? Does it end when his successor enters upon the office? Does it end when he himself resigns? Or does it end when his appointment is terminated by the orders of the president? Answers should come in now. When does it end? When does the tenure of a governor end? After 5 years, when a successor, after 5. No. So let's go back to understanding what it is. No. It is when his successor enters upon office. Yes. Charvi, not option one. Hiba, not option four. It is option two. When his successor enters upon his office. What Article 156 says, there shall always be a governor in the state, notwithstanding whether the 5-year term has ended, notwithstanding whether he resigns or the termination happens. He stays in office until his successor comes in. So the termination might happen, everything might happen, but he cannot leave the office until the successor steps in. Come on, let's go. Yes, Garima, let's conquer. Jeet lo judiciary hashtag. Let's go, guys. Next question. What is the right against double jeopardy? What is meant by the right against double jeopardy? Is it the right that you should not get prosecuted for the second time for the same offense? Is it the right you have against being imprisoned? Is it the right you have to receive legal representation? Or is it the right to be heard by the court? All right. Ayushi, you're trying and you will succeed. That's right. We have it correct. All of us here, excellent. It is the right to not get a second prosecution for the same offense, and it is contained within Article 22 of the Constitution. Next question. What is India called in Article 1 of the Constitution? Is it called a federation? 2, Union of States? 3, Bharat? Or is it called both options 2 and 3? Timer starting now. What is it called? Article 1 of the Constitution. Let's recapitulate what Article 1 says quickly. Bharat something. No. Article 1 reads, who said Bharat? I think Hiba said Bharat. Article 1 reads, India, that is Bharat, shall be a union of states. So it is called both Bharat and Union of States. Next question. Which of these are reasonable restrictions under Article 19(2) of the Constitution? 1. Reasonable restrictions. Again, we have restrictions differently for different portions of Article 19. Is it 1. Defamation and incitement to an offense? Is it 2. Sovereignty, integrity of India and security of state? Is it 3. Public order, decency, morality, and friendly relations with foreign states? Or is it 4. All 3? Timer starting now. George, yes, Article 1 says India, that is Bharat, is a union of states, shall be a union of states. Your correct answer is 4, all 3. Excellent. Ayushi, not answer 3. It is 4, all 3 of these. These are enlisted as reasonable restrictions for the freedom of speech and expression. That is 19(2). Sovereignty, integrity of India, security of state, friendly relations with foreign states. There is public order, then there is decency, there is morality, contempt of court, defamation, and then incitement to an offense. So important that we remember all the qualifications and restrictions here. Next question. The idea of fundamental rights in the Indian Constitution was borrowed from which of these? The Canadian Constitution, the Spanish Constitution, the Irish Constitution, or the Constitution of the US? Guys, fundamental rights. Where did fundamental rights come from? Some of us think it's the Irish Constitution. No, not the Irish Constitution. That is for DPSPs. This is the Constitution of the United States. That was one of the features borrowed by the US Constitution, borrowed from the US Constitution into the Indian Constitution. Next question. What does Schedule 10 in the Indian Constitution? What does Schedule 10 provide for? 1. Anti-defection laws. 2. Union list, state list, and concurrent list. 3. List of states and territories of India. Or 4. The languages. Schedule 10. Timer starting now. Let's get ahead of ourselves. Yes, someone thinks it's anti-defection. Yes, anti-defection. Yes, Schedule 10 is for anti-defection. And when was this introduced? 52nd Amendment, 1985, to curb crossing the floor or political defections, as we saw then. Question 25. Per Article 61, the impeachment of a president requires which of the following? Does it require a special majority of both houses of parliament and all legislative councils to pass? 2. Does it require a simple majority of both houses of parliament to pass? 3. Does it require an absolute majority of the House of People to pass? Or 4. Does it require a special majority of both houses of the parliament to pass? Which of these? The timer has started upon us. Let's go. We need pace if we want to qualify DJS, and it is a special majority that is required. George got it right. Taleen got it right. All right. A complete reading of Article 61 will show you that in order to impeach a president, both houses of the parliament will need to pass the resolution, and each house will need to pass it with a special majority. So, two-thirds and up, which is a special majority. Next question. The term bona vacantia for the purpose of the Indian Constitution means which of the following? Those of us who are not aware of this term need to keep an eye out and learn. What does the term mean? Does it mean a property which has no rightful claimant will, in all cases, be taken up by the state? Does it mean that the end of a right of one person and then the right is vested in another person? Does it refer to the period of absence of a speaker from the House of People, or does it refer to statements made in good faith? Your timer has begun now. Answers. Come on, let's see answers, guys. The correct answer is 1. Yes, Nida, the correct answer is 1. Bona vacantia refers to a property that has no rightful claimant, and then it moves on to the state because it has no rightful claimant. All right. So a property for want of a rightful owner goes to the union or goes to the state. This is in Article 296 of the Constitution. You'll find the relevance there. Moving on, which of these bodies are independent agencies under the Indian Constitution? Is it the institution of CAG, the Comptroller and Auditor General of India? Is it the Election Commission? Is it the PSC, the Public Service Commission? Or are all three bodies independent agencies? Your timer starts now. Which body is an independent agency, guys? Come on. Sovik Singh, it's CAG. All three are independent agencies. So all three need to function independently, guys. The CAG is he's the purse checker. He's keeping check on the purse of the government. He keeps the purse of the government. He needs to be independent. The Election Commission needs to be independent. The Public Service Commission, these bodies need to be independent. Let's think. They don't want to be under the influence of the government. Next question. Which case challenged the validity of 3 amendments? 25th, 26th, and 29th Constitutional Amendment. Was it case Sunanda Bharti versus State of Kerala 1973? Was it the Minerva Mills case 1980? Was it Indraswamy versus Union of India 1992? Or none of these? Some of us think it's none of these. Abhay thinks it's case Sunanda Bharti versus State of Kerala. What do the rest of us think? Come on, guys. It is case Sunanda Bharti. In respect to the Kerala Land Reforms Act, KV Bharti case challenged all 3 amendments of the Constitution. Next question. The Parliament and the state legislatures may do which of the following? What are they empowered to do? Can they make laws for the whole or any part of the territory of India? Can they make laws for the whole or any part of the states in India? Can they do both 1 and 2? Or can they make laws for the whole or any part of the territory of India and make laws for the whole or any part of the state respectively? So which portion belongs to which? What do you think? I'll give you a few extra seconds to get the question right. And then I'll start the timer. Starting the timer now. 4. Excellent. So these are just words trying to confuse you. 4 is correct. The first portion, to make laws for the entire territory of India, belongs to the Parliament. The second portion, making laws for the state, belongs to the state legislature. And this is under Article 2451. 4 with exceptions. Excellent, George. 30th question. Article 14, Clause 4A was inserted by which of the following? 1. 77th Amendment Act 1995. 2. 42nd Amendment Act 1976. 3. 50th Amendment Act 1984. Or 4. The 4th Amendment Act in 1955. Back in 1955. Which of these was it? 14 Clause 4A is what we are talking about. Someone thinks it's the 1977. I didn't discuss the 1977 one, guys. It is the 77th Amendment, right to be. 77th Amendment Act was what happened in 1995, and it added Clause 4A to the Article 16. What it did was it empowered the state to make reservations with respect and in favor of scheduled castes and scheduled tribes of India. Next question. It is the duty of the Union to protect states against external aggression and internal disturbances, as provided under which article? What article expresses this duty of the Union? Article 352, Article 354, Article 360, or Article 355? Timer starting now. Come on. 355. 355, Shubham. 355 reads that it shall be the duty of the Union to protect states against external aggression and internal disturbances. Shubham, right now is when you go, write it down to the side and then go back to 352 and 355 and try to, memorize again. Question 32. Can the Parliament provide for the establishment of certain additional courts? Yes, it can. The Parliament has the express power to do so. That's option one. Option two is no, the Parliament does not have this power. Option three, the Parliament can only do this at the recommendation of the Legal Secretary of India. Option four is the Parliament can only exercise this power on the recommendation of the CJI. So, how can the Parliament create additional courts if at all it can? Your timer is starting now. Don't worry, Shubham. Let's move on to the next question. And the correct answer is right. George got it right. Indu got it right. The correct answer is yes, the Parliament has the express power to do so. Why? 247 expressly empowers the Parliament to establish additional courts for the purpose of administering laws better throughout the territory of India. Next question. Which of the following is a directive principle of state policy? Quite easy to get, but let's answer it quickly. Right to education, right to property, right to move the Supreme Court, or the right to organize village panchayats? Timer starting now. Which one of these is it? Yes. Fourth, this is in Article 40, which states that the state shall take steps to organize village panchayats and give them powers and authority required so that they can function as units of self government. And the rest were fundamental rights, not DPSPs. Question 34. Which one of the following writs can be issued only against the judicial or quasi judicial authorities? Which writ is such that it can be only exercised against these two bodies, these two classes of people? 1. Prohibition, 2. Quo warranto, 3. Habeas corpus, or 4. Mandamus? Your time starting now. Yes, George, right to education is a fundamental right. Yes, exactly, guys. Prohibition. Prohibition where the court prevents, a higher court prevents the lower court from overstepping its authority. And that is why it is used against a judicial or a quasi-judicial authority. Next question. Jyoti, it was 1 prohibition, not 2. Question 35. According to Article 39A of the Constitution, what does the legal system of the country seek to promote? 1. Does it seek to promote effective maintenance of law and order in the country? 2. Is it for the obedience to the law? 3. Is it for effective resolution of dispute between parties? Or 4. Is it for equal opportunity justice? Is it to provide equal opportunity justice? Let's see the answers coming in. The timer has started. Only 5 seconds. Let's speed up the question solving. Excellent, guys. It is to ensure justice to be equally accessible, or as it is called, equal opportunity justice. The state shall secure that the operation of the legal systems promotes justice on a basis of equal opportunity. And then it also deals with provision of free legal aid. Next question. The maximum time period to fill up a vacancy in the office of president due to death, resignation, or removal of the president is? What is the maximum time period that it can stay vacant, the president's office? Is it 6 months, 3 months, 60 days, or 1 year? Your timer has started now. Guys, answers. What is the time period? Divya Raj thinks it's 6 months, 6 months. And we are right. Only 5 to 6 people could guess. Come on. Yes. 6 months. And what is relevant here? Article 62.2, that 6 months, no later than 6 months from the date of occurrence of vacancy, should the position be filled. Next question. For the impeachment of the president, for the president of India to be impeached, the charge shall be preferred by whom? Lower house of the parliament, upper house of the parliament, either house, or both houses of the parliament at the same time? What should be the answer, guys? The president's impeachment. 3. That is correct. 61(1), that impeachment for violation of constitution, for the purpose of violation of constitution, charge is preferred by either house of the parliament. Next question. We discussed a similar question before, so it was easier to guess that. Question 38. The Council of Ministers remains in office so long as it enjoys the confidence of whom? Whose confidence does the Council of Ministers need to enjoy? The President, the Speaker, the Prime Minister, or Lok Sabha? Timer starting now. Kumar thinks it's the Speaker. Talin thinks it's the Lok Sabha. It is the Lok Sabha, Kumar. Kumar, Hiba, it is the Lok Sabha. The Council of Ministers remains in office so long as it enjoys the confidence of the Lok Sabha. Right? Article 75, relevant here. Next question. A proclamation of national emergency automatically will suspend which of the following? Will it suspend the right to constitutional remedies? Will it suspend all of your fundamental rights? Will it suspend the right to freedom? Or will it suspend the right to equality? Answers, guys. The timer has begun. Right to freedom. It will suspend the right to freedom. Pritika, not the right to constitutional remedies. That is very key. No, guys, the right to freedom. You can still move the constitution for the violation of your basic 20 and 21. It can still be moved. But the right to freedom, it entails freedom of movement, of profession, and all those things. They become secondary at the time of proclamation of emergencies. What if your right to life is violated? What if 20 or 21 is violated? Where do you go? That is not suspended. You have to be able to move to the court. So 3 right to freedom can be suspended temporarily. Question 40. Who appoints the Attorney General of India? How is the appointment of AGI made? By the Parliament, by the President, by the PM, or by the CJI? Who does it? Your timer starts now. Answers coming in. Pritika thinks it's PM. Payal thinks it's the President. It is the President. The President only appoints the Attorney General of the India. Someone who is qualified to be a judge of the Supreme Court can become the AGI. This is in 76(1). Next, the quorum for meetings of the House of People. What is the quorum for meetings of the House of People? Is it 1/3 of the total members? Is it 1/2 of the total members? Is it 1/10 of the total members of the House, or none of these? Your time has begun now. Okay, some of us think it is 1/10, and we are right. Not option 2, it is 1/10 of the total members. Go back to Article 103, that until the Parliament by law otherwise specifies, the quorum to constitute a meeting of either House of Parliament shall be 1/10 of the total number of the members of the House. 3, 1/10 of the total members. Next question. Disputes between states in India come to the Supreme Court under which of its jurisdictions? Is it the review jurisdiction of the Supreme Court that allows it to deliver on disputes between states? Is it appellate jurisdiction, advisory jurisdiction, or original jurisdiction, guys? Advisory, original, appellate, or review? These are disputes within interstate disputes. These are original, guys. When two states fight, the Supreme Court is the head of the family. The Supreme Court steps in. Original jurisdiction, not review, not appellate. We go back to 131, and it gives the Supreme Court original jurisdiction in these kinds of disputes between states, between the government of India and a state, or between 2 or more states, where the dispute has at its crux something which is depending for the extent of a legal rights, a law of a statement of law, a statement of fact, a question of law, a question of fact. There, when there is a dispute between 2 states, in these situations, original jurisdiction empowers the Supreme Court to take charge. Let's see how many types of justice have been enshrined in the preamble of the Constitution of India. 2 types of justice, 3 types of justice, 4 types of justice, or just 1 type of justice? Come on, guys. Let's see some answers coming in. 3. Excellent. 3. What are the 3 kinds? Justice should be social, economical, and political. Next question. The significance of the word court on record. The Supreme Court is a court on record. What does that mean? Does it mean that it has to keep a record of all of its decisions? Does it mean that all of its decisions will have evidentiary value and they cannot be questioned in any court because it was the Supreme Court that delivered it? Or does it mean it has the power to punish for its contempt? Or does it mean that no appeal can be made against its decisions? Answer very carefully. Your timer has begun. Let's see. And the correct answer is that all its decisions have evidentiary value. They cannot be questioned in any court of law because the Supreme Court's decisions are binding on the entire court machinery of the country. Article 129 states that it is a court of record and it has the power, including the power to punish for the contempt itself. Next question. Can a written letter by a convict to any of the judges of the Supreme Court be treated as a writ petition? 1. Yes. 2. No. 3. Only on the discretion of the President. 4. Only when it relates to offences under the IPC solely. What is the answer here? Can a writ petition as a written letter qualify? A written letter, can it become a writ petition, guys? Yes, it can. Sunil Batra versus Delhi administration. What was done? A written letter was sent by a convict to one of the judges, and that is how we uncovered the plight of the convicts. So, option 1 is correct. A written letter is treated as a writ petition, as it has been in Sunil Batra's case. Next question. Special leave petitions are filed under which article of the Constitution? Article 32, Article 21, Article 226, Article 136. Special leave petitions, guys. Time is starting now. Special leave petition. Some of us think it's 32, some think it's 136. It is 136. Special leave petitions are not entertained under 32. Shubham, 136 is the correct answer. It will vest the Supreme Court, the apex court of the country, with a special power to grant special leave to appeal against any judgment or order or decree in any matter or cause which is done within the territory of India by courts under the Constitution of India. The President will appoint all but not which of these? All right. Who of these shall the President not appoint? The Attorney General, the Chief Election Commissioner, the Advocate General of State, or the CJI? Time is starting now. President will appoint all but not whom here? Correct answer is, of course, Attorney General. Attorney General is a constitutional office created under, sorry, not of India, of state, the Advocate General of State. It is a constitutional office created under 165. Now, the governor will deal with it. The attorney is at the center and the president deals with it. But the governor will deal with the Advocate General of India. So this is a person who is qualified to be a judge of the High Court, and then he is considered for the position of the Advocate General of India. Similarly, just like we saw a few questions ago, for the Attorney General of India, who goes in? A person qualified to be a judge of the Supreme Court. For the Advocate General, a person who qualifies to be a judge of the High Court. And here the governor takes charge and appointment. Next question. The pension of the judge of the High Court is charged to which of the following? Pension of the judge of the High Court. High Court. Consolidated fund of the state where he last served, the High Court judge, the Consolidated Fund of India, or the Contingency Fund of India. Two different things. Or none of the above. Where is it charged? Let's see answers come in. Talin, Pritika, George, Hiba, Nida. What is the answer? The answer is the Consolidated Fund of India, not the state where he served last. Go to Article 1123, and within the expenditures that are charged upon the Consolidated Fund of India, one entry is the pension payable for judges of any high court in respect or for judges of any high court. So the Consolidated Fund of India itself. Next question. A person whose fundamental rights are violated can move to the High Court under which article? These are things we have discussed and should be on the tip of your tongue. Article 20, Article 226, Article 32, or Article 22. Time is starting now. Excellent. We want to see speed in these easier questions. And 226 empowers the High Courts to take up these situations. High Courts to be moved. Next question. What shall be the official language of the Union? I expect this also to be on the tip of tongues. 1, English. 2, any language as specified in Schedule 8. 3, Hindi. And 4, Hindi in the Devanagari script. What should it be? Any language specified in Schedule 8? Some of us are answering. The correct answer is Hindi in Devanagari script, guys. It's Article 343.1 that states this, that the official language of the Union is Hindi in Devanagari script. Now, this form of numerals, it used to be for the official purposes of the Union. Next question, 51. In which of the following cases did the Supreme Court hold that the Constitution should be interpreted in such a manner so as to secure the goal of social, economic, and political justice? So, the three kinds of justices we just uncovered a few questions ago. Was it the case of Sajjan Singh versus State of Rajasthan, where the Supreme Court said this? Was it S.R. Bomai versus Union of India? Was it K.K. Bhaskaran versus State? Or was it Nandini Sundar versus State of Chhattisgarh? Which case was it? Your timer has begun now. Answers coming in. We think it's Sajjan. Someone thinks it's S.R. Bomai's case. And the correct answer is K.K. Bhaskaran, guys. No one guessed it? George? No, Pritika guessed it. K.K. Bhaskaran's case was where the Constitution, where it was said about the Constitution by the Supreme Court that it should be interpreted in such a manner so that we secure social, economic, and political justice all in one go. Next question. In which of the following landmark cases did the Supreme Court hold that the right to equality was framed in gender neutral terms by the use of the words all persons, and this gender neutrality extended to transgenders also? Was it in the case of Magan Lal Shagan Lal versus Municipal Corporation of Greater Mumbai? Was it in the case of Vishaka versus Rajasthan? Was it in the case of Harsh Mandar versus Union of India? Was it the case of Nalsa versus Union of India? Some of us are guessing 4. Only Hiba, I guess, stated 1, or was that for the earlier question? It is 4, right. In the case of National Legal Services Authority versus Union of India, the Supreme Court has held that the right to equality is gender neutrally framed by using the word all persons and not men or women. Next question, guys. In which of the following landmark cases did the Supreme Court rule that fundamental right to privacy is intrinsic to life and liberty, and thus the fundamental right to privacy is within Article 21 of the Indian Constitution? Was it the case of MC Mehta versus Union of India? Was it Lily Thomas versus Union of India? Was it case Puttaswamy versus Union of India? Was it PUCL versus Union of India? Excellent. So some cases stick with us. Is it the names? What is it? Puttaswamy. Yes, guys. Some things we all remember. Puttaswamy's case, it was about Aadhaar cards. Remember the whole debacle about Aadhaar cards? And that is how we uncovered that privacy is within Article 21. Next question. In which of the following cases did the Supreme Court hold that if an educational institution has not been established by the minority community, then they have no right to administer it? If the educational institution has not been established by the minority community that is in question, they won't have a right to administer it. Which case held this? Was it the case of Naresh Agarwal versus Union of India 2002? Was it Aziz Basha versus Union of India? Was it DAV College Batinda versus State of Punjab and others? Was it Syed Asrar Ahmad versus the Dargah Committee? I will begin with the timer now. I'm not receiving a lot of comments. Come on, guys. Where's the confidence? Batinda, DAV College case. What do we think? It is Aziz Basha's case. Aziz Basha's case explored the idea of the Aligarh Muslim University, guys. That is what was challenged there, the Aligarh Muslim University and its administration. And in this case, the Supreme Court held that an educational institution goes to the minority for administration only if it has established it. If it has not established it, if the minority community does not have a magnificent role to play in the establishment, then the administration won't go to it. That was the dictum here, Aziz Basha's case. 55th question. We are more than halfway through. The ninth schedule to the Indian Constitution was added by which of the following? Quick answering questions. 1. First Amendment. 2. Eighth Amendment. 3. Ninth Amendment. Or 4. 42nd Amendment. Which one of these was it? Your timer is beginning. We think it's the First Amendment that the ninth schedule was added. And correct, the ninth schedule added by the first constitutional amendment of 1951. What did it do? It added 2 articles, 31A and 31B. What it did was it protected agrarian reforms. It was for the protection of agrarian reforms in certain states. Next question, and within after a few questions, we'll be taking a brief break, guys. 56. Which amendment added the duty of the state to provide for free legal aid as a directive principle? Free legal aid as a directive principle. Again, we briefly discussed it just a few questions ago. Was it 42nd Amendment 1976? Was it 44th Amendment 1978? I see that Yash is happy about cricket. That's good too. Was it the 73rd Amendment 1992, or was it none of these? Yash, let's play some sixes and boundaries over here too. Come on. Which one of these was it? The timer has begun. Yash, let's answer. I want you to perform just as well as our cricketers right there. The correct answer is 42nd Amendment, guys, 1976. Yash, I didn't see you answer. 42nd Amendment added 4 new directive principles in the list, and these were 39 was for the securement of opportunities for healthy development of children. 39A was equal justice and free legal aid, like we discussed. 43A was to take steps to secure participation of workers in management of industries, and 48A was for the protection and improvement of forests and wildlife. Next question. Which constitutional amendment established a national commission for scheduled castes and scheduled tribes? This also I gave you a cue many questions ago. 1, was it the 61st Amendment? 2, was it the 65th Amendment? 3, the 77th Amendment, or the 78th Amendment? Which one of these helped establish the National Commission? This is how I know who here is an attentive listener in the explanations. Everything is important from the question to the explanation. This was the 65th Amendment. No. Option 2, 65th Amendment. The 65th Amendment of 1990, it established a national commission for the SCs and STs. The 61st Amendment, what it did was it amended 326, reducing voting age from 21 to 18 years. The 77th Amendment, what it did was it amended Article 16 for making the provisions of scheduled castes and scheduled tribes to any class of posts in the. Just a moment. These are national, yeah. That is why you got confused. So 77th Amendment, what it did was the reservation portion, and the 65th Amendment, the question was what allowed for the establishment of national commission for these bodies, for these classes of people. And the correct answer for this is 65th. Okay, guys? So let's not get confused. Let's read the questions correctly. And then the 78th Amendment, it added various state legislations, the saving of various state legislations for ninth schedule, which is the various local laws that we have. Next question. As soon as we reach 60, we'll take a brief breather. So the question is, by which constitutional amendment act were the words armed rebellion substituted for internal disturbance to prevent the misuse of emergency provisions? So they didn't want everything to qualify as armed rebellion. They wanted internal disturbance to be a very sorted term for the application of emergency provisions. What did it? Was it the 42nd Amendment, 44th Amendment, 61st Amendment, or the 74th Amendment? Most of us get confused between the contents of the 42nd Amendment and the 44th Amendment. George Philip, Moraji Desai government, yes. So the correct answer here shall be the 44th Amendment, guys. The 44th Amendment, 37A, Section 37A of the 44th Amendment. What it did was it amended Article 352, changing the words internal disturbance, putting them in there instead for armed rebellion. Next question. Short title of Constitution of India is defined under which article? Is it Article 1? Is it Article 2, Article 393, or 394? A very important question. I want to just gauge everyone with a bit. And the correct answer is 393. We get confused and we tend to answer it with India, that is Bharat shall be a union of states. It's Article 1. I know it's Article 1. No, the short title, funnily enough, it's not in Article 1. It's in Article 393, way back in 393. And it says something like this. It says this constitution may be called the Constitution of India, giving us the short title of the Constitution of India. We don't want the short title of the country. We don't want India, that is Bharat shall be a union of states. That is Article 1. We want the short title of the Constitution. And we have to remember that it is in 393. 3 times 3 is 9. It's in 393, the short title of the Constitution of India. And a question before a quick breather so that we can chat a bit. This is question 60. What does Article 361 provide for? Come on, guys. Does it provide for authority of union government to dismiss state governments? Does it provide for authority of state governments to pass legislations? Does it provide for protection and immunities to the president and governors from being prosecuted in courts? Or does it provide for none of these? Does it provide for something else entirely? Timer starts now. What does it contain? Protection immunities or authorities of union or state governments? The correct answer is 3. Excellent. Most of us, in fact, all of us are right. 3. It protects and provides immunities to presidents and governors from being prosecuted in courts. 361. The Constitution of India, it deals with the protection of president, governors, and even Raj Pramukhs. So, just a brief breather so that we can all take a sip of water, reflect on how much we got right. I would like to see who has been keeping a tally. So let's start. Tell me how many questions you have gotten right so far. Come on, guys. I would like to see in the chat how well we are doing. Come on, anyone? Komal, Shubham, George. How many questions do you guess you got right if you're not keeping a tally? 4 questions wrong. That is nothing, Shubham. That means you're doing excellent. 4 questions wrong. Let's make sure we have written down those questions or something, at least the article number of the question, so that you can go back and revisit why you got it wrong. 7 wrong, 2 unanswered. Fine. Not an issue. This is for us to brush answering time and for us to practice. And if you get it wrong here, no issue. As long as you are learning and not repeating the same mistake in the prelims, I am on board with your incorrect answers. I am all for your incorrect answers. Keep answering the questions incorrectly. Just don't answer them incorrectly in the prelims. 3 unanswered. Okay, Komal, you should have just gone ahead and answered those 3 as well. The worst that could have happened was that you would have gotten them wrong, but then within 5 seconds, you know which way is right. 5 to 6, Divyaraj got wrong. George got the first DPSP question wrong. I still doubt. Okay, no problem, George. Who else? Let's keep it going. So how is the session so far? Is everyone feeling energized? How is the preparation going? You can also tell me about the mocks. You can refer to me via your DJS WhatsApp group. You have my number. Any issue, anything you encounter, any question you have a confusion with, just drop me a personal text immediately. I'll get back to your issue and help you out. How is the mock going? Have all of us here attempted the mock? Because see, without the mock attempts, these are just stilts holding up the mock attempts. The mock is the main thing here. Your marathons and quizzes only, they act as supplements to your mocks. Excellent, Komal. Who else? Is Komal the only person who is excited to crack DJS? Come on, guys. Komal is the only person. Where did Yuvraj go? Did we see Yuvraj batting here? I want to go back to the cricket comment. Yash. Yash, how is the Josh? Shaktija has attempted all mocks. Excellent. Excellent, Shubham. Pritika, very interesting, interactive. Yes, thank you, Pritika. Let's keep it going. Let's keep the interaction from everyone's end. Make sure you're trying to answer all the questions and listening to the question or reading the question properly. Make sure nothing is missed in the question, right? Sometimes your eye tends to scroll ahead in the question and you miss out key details. That should not happen, because with Delhi judiciary, they tend to, even if they ask small questions, the question is full of surprises. You have to pay attention to all the details. Otherwise, you will feel like you messed up when the key comes in. You know you messed up. So read the questions well. Keep the pace going, but read the questions well. All right, guys, should we resume? Are we ready for question 61? We have up to 25 minutes now. Are we ready? Or do we need a few more minutes? Questions are eye openers. Yes, we want to open eyes with the mocks as well as with the quizzes. All right, we shall begin now. Let's get our thinking caps back on, guys. Excellent, everyone is ready. All right, with that, we have question 61. Question 61 is Article 14 of the Indian Constitution does not prohibit which of the following? Not prohibit. What is not prohibited in Article 14? Class legislation, special treatment to an individual, treatment of unequal at an equal footing, or reasonable classifications. Your timer starts now. Let's go. Attempts at the correct answer coming in. What is not prohibited? 4. Reasonable classification is not prohibited. Class legislation is forbidden. You cannot make a legislation for one class, make a legislation for the other class, which does not apply to it. Where it is a reasonable classification based on persons, objects, or transactions by the legislature, and it has a specific end, it has a specific legal end for such a discrimination, that is allowed. And that classification, that divide, is called a reasonable classification. Next question. Which one of the following officials is appointed by the president on the advice of the PM? So, is it the Chief Justice of India who is appointed in this manner, the governor of the state, the chairman of the UPSC, or all of the above appointed by the president on the advice of the PM? Let's see how many of us think that the PM needs the advice, the president needs the advice of the PM. Correct answer, guys? It is all of the above. Appointment of judges of Supreme Court, Chief Justice as per 124(2) of the Constitution, appointment of governor under 155, right? And 316, the chairman, other members of the UPSC, they are appointed by the president with the advice. Question 63. On whose written request can the president declare national emergency under 352 of the Constitution of India? Is it the written request of chief ministers of all states? Do all chief ministers band together to write a request? Is it the prime minister? Is it the cabinet ministers headed by the prime minister, that the prime minister requires the cabinet ministers as well? Or is it the council of ministers? Yes, just like this is how we want questions to be answered. The timer has not started, but we are answering. We do not care about the timer at this point. Cabinet ministers headed by the Prime Minister. 3, correct. National emergency under 352, as discussed, states that the President can declare such an emergency only on the basis of a written request by the Cabinet headed by the PM. Let's beat the timer once again for this question. We have too much Josh to consider the timer. Article 48A of the Constitution of India deals with which of the following? Is it promotion of equal justice and provision of free legal aid to the poor? 2. Provisions for the healthy development of children. 3. Protection and improvement of the environment and safeguarding of forests and wildlife. Or 4. All of the above. Again, fine attention to detail plays a part here. I'm giving you extra information in the previous question so that it helps you ahead. Excellent. Answer 3, protection and improvement of the environment and safeguarding of forests and wildlife. Again, added by the 42nd Amendment when? 1976. And the state shall endeavor to do these things: protect and improve environment, safeguard forests and wildlife of the country. Next question. Which of the following statements is correct with respect to DPSP? The DPS policies, are they state policies? Are they non-justiciable, non-enforceable? Are they justiciable, non-enforceable? Or are they non-justiciable but they are enforceable? Or are they justiciable but they are non-enforceable? Confusing terms, but they are very different terms and we must know the difference. Some of us think it's 3, some think it's 4, some think it's 1. It is 1. They are both non-justiciable and non-enforceable. You cannot go to the court asking for the application of DPSPs, and you cannot go to the executive asking for the enforcement of the DPSPs, right? So they are just endeavors, they are ideals and principles for the state to reach through legislative means, and non-justiciable and again non-enforceable. They are not your fundamental rights, not the same gravity as fundamental rights. Question 66. In the state legislature, which body cannot introduce a money bill? Which body will not be able to introduce a money bill in the state legislature? The Legislative Assembly, the Legislative Council, the governor of the state, or the CM of the state? Who cannot introduce a money bill? Come on, guys, answers. Answers should come in. Excellent, the Legislative Council. It is specifically stated that the Legislative Council shall not be introducing a money bill. They have to be introduced through the legislative assembly, and then they go to the Legislative Council for recommendation. So 198(1) specifically bars the introduction of legislative of money bills via the Legislative Council. So there is a specific bar there. So that is what we meant by this question. Next, 67. The parliament has a sanctioned strength of how much in the Lok Sabha and then how much in the Rajya Sabha? What is the magic figure here? Is it 543 in the Lok Sabha and 245 in the Rajya Sabha? Is it 556 in the Lok Sabha and 280 in the Rajya Sabha? Is it 541 in the Lok Sabha and 211 in the Rajya Sabha? Or are none of the above combinations correct? The timer has begun. Some of us think it's 2, most think it's 1. And the correct answer is 1, of course. 543 in the Lok Sabha and 245 in the Rajya Sabha. 245 include 12 nominees from the expertise. We have different, people in the top of their fields, people in the top of literature, art, science, social service. They are counted within the 12 nominees. And this is further elaborated upon in Article 81, where we discuss the composition of House of People. Next question, 68. Article 13(1) is what in nature with respect to the enactment of the Constitution? With respect to the enactment of the Constitution, how can we describe Article 13(1)? Is it retrospective? Is it prospective? Is it devoid of any application based on time? Is there no element of application, whether retrospective or prospective, that is specifically stated there? Or does it apply in this manner in a manner that is decided by the Supreme Court, whether it is with time or with respect to application? What is the effect of Article 13(1)? Some people think it's prospective, some are voting for retrospective. That is option 1. And the correct answer is it is prospective. It is prospective. Article 31, the making of laws void if they clash with the fundamental rights. They don't make those laws void back in time. It is prospective. It happens, I asked in the question, with respect to the enactment of the Constitution. With respect to the enactment of the Constitution, the being void of the specific legislation happens after the enactment of the Constitution. So it looks forward, prospective. It doesn't look back. It's not retrospective. It is prospective. They are not void ab initio. You cannot go back in time and make them void there. That is not how 13(1) is envisaged in the Constitution. Next question, 69. The Supreme Court held that no person can be compelled to sing the national anthem in which of the following cases? We should all know this. 1. Secretary, Ministry of I&B versus Cricket Association of Bengal, 1995. 2. Union of India versus Association for Democratic Reforms. 3. Bijoy Emmanuel versus State of Kerala, or none of the above. Very good. Even Garima ma'am is stepping in. Yes, George, it was the case of Jehovah Witness, the people of the Jehovah Witness faith. Very good. Bijoy Emmanuel. The Supreme Court held that if a person has genuine conscientious objections based on religious faiths, you cannot subject them to force or a or a compulsion so that they have to sing the national anthem. It is protected. Your silence is protected under 19(1)(a) as part of your freedom. Next question. The right guaranteed in Article 21. What class of people is it available to? Citizens, non-citizens, both 1 and A, or is it citizens and only in a limited capacity applicable to non-citizens? Which of the following is it? Your timer has begun. Let's beat the timer again. Come on, we want to show the timer that we don't need it. We know the answer already. Correct. We did know the answer already. It is available to both citizens and non-citizens. Just like we saw that some places the language of the Constitution is gender neutral. Here the language of the Constitution can be said to be citizenship neutral. We don't want to know whether the person is a citizen or not. The use of words is no person shall be deprived, which means irrespective of the status of citizenship, 21 applies. Next question. Who inaugurates the parliament by addressing it after the general elections? So how is the inauguration of the parliament done? Is it done by the president, the prime minister himself, the vice president, or do the council of ministers inaugurate the parliament? The timer has begun now. Someone thinks it's the president. Most votes coming in for president, and we are correct. The president does the inaugural. Yes, the president does the inaugural speech at the parliament after the general elections happen, and also at the beginning of each first session each year. And this is in Article 87. So, what it does is it gives the president an opportunity to outline the new policies of the government, because these are fresh starts for the government. Next question. Which Amendment Act established the three-tier government system, guys? Was it the 73rd Amendment Act of 1992, the 74th Amendment Act, the 75th Amendment Act, or was it established via both 1 and 2? That is the 73rd and 74th. Shubham thinks it's the 73rd Amendment Act, so option 1, 73rd, option 1. It was both 1 and 2. So by the 73rd and 74th Amendment Act, the establishment was done. Again, I said, how was it established? So both happened. Originally, we had the center and the state system, but the provisions for the extended establishment of the three-tier, the panchayat system, was done by both the Amendment Act 73rd and 74th. So we cannot exclude either when it comes to the application of the three-tier system, the Panchayati Raj system. Next question. Article 51A enumerates fundamental duties which are imposed on. Who are fundamental duties imposed on? Every person. 2. Garam got it wrong. 2. Citizens only. 3. Indian nationals only. Or 4. None of the above. George thinks these are on every person. The timer has begun now. Muskan thinks it's for citizens only, the fundamental duties. George thinks every person. These are citizens only. George, we were referring to fundamental duties. Fundamental duties inserted by Part 4 of the Constitution, 42nd Amendment Act 1976. 51A, we saw being inserted, enumerating 10 fundamental duties, and these are assigned to citizens and not non-citizens. And again, just like DPSPs, they are non-justifiable. So this is for citizens only. The duties are from citizens only. Just be a bit careful, George, in reading the question. Let's not, like I said, sometimes we tend to skip ahead a lot. So question 74. Under the Constitution, which body cannot be dissolved? So Garima ma'am is keeping score. Where are her scores? Garima ma'am knows how many she got right and how many she got wrong. What body cannot be dissolved? Lok Sabha, Rajya Sabha, both 1 and 2, or neither 1 nor 2. Your timer has begun, which I am happy. We don't need Rajya Sabha. Someone thinks it's Indu Kumari thinks it's Lok Sabha. No, Indu has corrected herself. It's Rajya Sabha. The Rajya Sabha, an interesting fact is that it enjoys continuity of life. Article 83, the Council of States, the Rajya Sabha, shall not be subject to dissolution, but as nearly as possible, 1/3 of the members of it retire as soon as maybe on the expiration of every second year. So every second year, 33% of the House of the Council of States is leaving. It's leaving, but the Rajya Sabha in itself never ceases to exist. 1/3 members might leave. So after how many years? After 6 years, the entire members might leave, but they will be replaced by other members, and they can. Okay, Indu read which of these can be. Okay. Fine, Indu, it's okay. Again, this is why you need to pay attention to what you're reading. Read well. Read with complete clarity of mind. The Rajya Sabha has continuity of life. It cannot be removed. 75. Who can transfer a judge from one high court to another high court? Who is capable of doing this? The president, the prime minister, the parliament, or the governor? Here's your timer. The transfer of a judge of a high court. Who does it? President. George, Muskan, Ishita. All right, excellent. No sham. Not the governor, not the prime minister. The president. Article 222. Article 222. The president may, after consultation with the Chief Justice of India. The Chief Justice of India is only in the capacity of consultation, but the transfer itself is done by the president. from one high court to another high court. Next question. We only have 24 questions to go through. Let's go, guys. Freedom of a person upon unlawful arrest is dealt with under which writ? Unlawful arrest. 1. Certiorari. 2. Habeas corpus. 3. Mandamus. Or 4. Quo warranto. Again, we are beating the timer. Excellent. Unlawful arrest, detentions, habeas corpus. Habeas corpus, which means present the body or have the body. So any person detained without being produced before the magistrate, habeas corpus is hit over there. Physically, the person needs to be brought before the nearest magistrate. 77, a bit about the inception of our constitution. The concept of liberty, equality, and fraternity. Where was it derived from? What is the place of derivation of this? Is it the laws of UK, the French Revolution, the laws of the USA, or none of the above? Come on, guys. What is the answer? We are right. It is the French Revolution. We remember the Statue of Liberty. The Statue of Liberty is in the USA, but let's not have that confuse us. It was a gift from the French to the USA upon their independence. So the French Revolution gave us liberty, equality, and fraternity. Next question, 78. Which article cannot be suspended during national emergency? Let me see how many of us have been paying attention. Article 20, Article 21, 22, or is it for both 1 and 2? Your timer has begun. Cannot be suspended. What cannot be suspended? 21. No, Archie. I said just a few questions ago, Archie, I said that both 20 and 21. What if they are violated? Who do you go to? You have to go to the Supreme Court still. So 20 and 21 will persist even in cases of emergency. Next question. 42nd Amendment. We saw so much about the 42nd Amendment, a lot about the 44th Amendment, but much about the 42nd Amendment. What has this been called in respect to the Constitution of India? Is it the spirit of the Constitution of India? Is it a revision of the Constitution of India, a backbone of the Constitution of India, or mirror of the Constitution of India? Your timer starts now. Backbone, mirror, a variety of options coming in. It is called to be a revision of the Constitution of India because of the dynamic changes it made. It created a sweep of changes. Firstly, it changed the description of India, first of all, from being a sovereign democratic republic to not just that, but a sovereign, socialist, secular democratic republic. It changed the words in the preamble unity of the nation to the unity and integrity of the nation. So these manifest changes it made. Yes, it's also called the mini constitution, Lakshita, but that was not in the options. It is a revision of the Constitution of India and also then known as the mini constitution. Again, why is it the mini constitution? Because of the amount of changes it made. Confusing question. Yes, guys, we will deal with many. We have dealt with confusing questions. Let's keep going, but that should not stop us. Come on, Shubham, try to focus on this one now. The law declared by the Supreme Court becomes law of the land as provided under which of the following? What provides that the law by the Supreme Court will become the law of the land? Article 131, Article 136, Article 141, or 151? Come on, Shubham, let's try to answer this. 141, 3, someone is answering 131 as well. It is 141, not 131, Talin, 141. As per Article 141 of the Constitution of India, the law declared by the Supreme Court shall be binding on all courts within the territory of India. And I also discussed this a while ago, which means it becomes the lex loci, becomes the law of the land. Next question, 81. Under the Constitution of India, which one of the following is not a specific ground on which the state can place restrictions on freedom of religion? So we saw a few questions about the restrictions under Article 19. This is another such question. So this is for restrictions on freedom of religion. Which of these is not a ground for restriction on freedom of religion? Is it public order? Is it social justice? Is it health or morality? Some people think it's health, some people think it's social justice. The correct answer is social justice. Health cannot be compromised. If the freedom of religion has to stop because of concerns of health, it will stop. We see 25(1) of the Constitution, subject to public order, morality, health, and to other provisions of this part, that is the fundamental rights part. All persons are equally entitled to freedom of conscience and the freedom to rightly and freely profess, practice, and propagate religion. So, social justice that can stop in light of the exercise of right of freedom of religion. 82. When the two houses of the parliament differ regarding a bill, how is the deadlock resolved? Firecracker restriction due to health. But then, George, the court will look into whether the firecracker is essential to your freedom of religion. It cannot, in most cases, it will be seen as not essential. So, deadlock resolution. George, let's get to this. A joint sitting of two houses, President of India, Prime Minister of India, or Speaker of Lok Sabha, who resolves a deadlock? Joint session, correct, guys. Joint session 108. 108 states that the Constitution states here that in case of a deadlock, a joint sitting of both houses is called. And who summons this? Additional bonus: the president summons this. And the bill is then passed by a majority of the total number of the members of both houses present and voting. So both houses are called. So the majority of the people present and voting is considered to resolve the bill finally. 83. Which part of the constitution deals with amendment? Which part? 10 or 20 or 11 or 6? Timer has ended. Part 20. XX is 20. 368 article specifically. So part 20 is where amendment of the constitution is contained. 84. Article 295 of the Indian Constitution provides for which of the following? What does Article 295 deal with, guys? Succession of the government of India towards properties, assets, liabilities, and rights and obligations in cases. 2. Things of value within territorial waters. 3. Reports of public service commissions. Or 4. Official language of the Union. 295. What does 295 deal with? Meda thinks it's succession of the government for certain things. Thinks it's territorial water. It is the succession of the government with respect to certain cases where property, assets, rights, liability, and obligations that existed before the constitution. After the commencement of the constitution, those become the liability. Those come over the what holds those things now. The government of India is said to be the successor after the commencement of the constitution of all those rights, liabilities, properties, assets, and obligations that existed. And quickly, things of value within territorial waters is for Article 297. Reports of PSCs is 323, and official language of the Union is discussed in 343. We already discussed this. Hindi in Devanagari script. 85. The 11th schedule of the Indian Constitution is concerned with which of the following? Is it concerned with matters of responsibility of municipalities? Is it concerned with matters of responsibilities of the state governments? Is it concerned with the Panchayati Raj provisions? Or is it for none of the above? Muskan thinks it's matters of responsibilities of municipalities. Shivani thinks Panchayat. Talin thinks Panchayat. It is Panchayat. Panchayati Raj system. 11th schedule, it elaborates on the powers, the authority, the responsibilities of the panchayats. And again, it was added by the 73rd Amendment Act of 1992. And this schedule has 29 subjects within it that the Panchayati Raj system has to take hold of: agriculture, animal husbandry, fisheries, etc. Next question. So remember, 11th schedule, 77th Amendment, 73rd Amendment, what was it? It was the Panchayati Raj system. Which articles of the Indian Constitution discuss the financial relations between the Union and the states? Articles 268 to 281, Articles 278 to 291, Articles 289 to 295, or Articles 168 to 171. So financial relations between the two entities, Union and state. Talin thinks it's 289 to 295. No, it's 268 to 281, option 1. 268 to 281, this is covered within part 12 of the Constitution, which is titled Finance, Property, Contracts and Suits, within which chapter 1 is finance. And then we see how the revenue is distributed between union and states. And this goes on from 268th article to our 281st article. So that is the or it's also known as the fiscal relationship between the union and the states. Which of the following is not a constitutional body? Which of the following is not a constitutional body, guys? Is it the Election Commission of India, the Comptroller and Auditor General of India? Is it the UPSC itself, or is it the institution of Lokayuta? Not a constitutional body. We know what the Lokayuta is, the ombudsman, the Swedish imported concept. Yes, it is the Lokayuta. Why? Because Lokayuta, Lokpal, the Lokayuta is the institution for the ombudsman. These are established via the 2013 Lokayuta Act, but not by the constitution. They don't enjoy constitutional status. What is on the screen, these are the constitutional bodies. These are the ECI, State Election Commission, State Finance Commissions. You have the National Commission for Backward Classes, National Commission for Scheduled Tribes. You have the Comptroller Auditor General, UPSC itself, Attorney Generals, tribunals, the Supreme Court of India. These are constitutional bodies and several more, but not the Lokayuta. So let's remember the Lokayuta is a statutory body. A statute has established it. Which statute? The Lokpal and Lokayuta Act of 2013, correct. But it is not a constitutional body. Yes, George, a statutory body. Thank you for bringing that clarification up in the comments. 88. Which of the following is not a part of the union executive? Not a part of the union executive. Is it the president, the vice president, the attorney general of India, or the chief justice of India? Come on, guys. Guess is coming through. Come on, George thinks it's option 4, CJI. Yes, it is the CJI. Why? He's not part of the union executive. This is why we have to pay attention to the question. We might, on the first glance, just expel the attorney general because he does not seem like a big figure right there next to the president and the chief justice. No, we are looking at the question. The question is asking us union executive. He, CJI, is the union judiciary member. That is in chapter 4. Part 5 deals with all these things. And in chapter 1, it talks about the executive. All of the three options in the beginning were the executive heads, and chapter 4 deals with the union judiciary, within which we deal with CJI, and specifically it tells us there shall be a Supreme Court 142, and within the Supreme Court there shall be a Chief Justice of India. Next question. Which article of the Constitution provides for exemption of property of the union from state taxation? So how is state taxation saved? State property saved from taxation, union property saved from taxation, sorry. Article 284, Article 285, Article 286, or Article 287. What saves union property from state taxation? Someone answered 285. 285, we are correct. 285 deals with exemption of property of the union from taxes levied by the state. Next question. Only 10 questions to go. Come on, guys. Let's increase the speed a bit more. The CEC, Chief Election Commissioner, can be removed from his office by 1. The President of India. 2. The Supreme Court of India. 3. In manners and grounds as applicable for removal of Judge of Supreme Court. Or 4. By government order. Your timer is here. Someone thinks it's the President. Most students think it is in manner and grounds for Judge of Supreme Court. That is correct. So the Chief Election Commissioner's removal will have the same intricacies, will have the same procedures as are required for the Judge of Supreme Court. 324.5 is important here. Pratibha, Lakshita, Muskan, focus. 324.5. Let's go back to 324.5 after this quiz. Write it down. It states that the CEC shall not be removed from his office except in a like manner as a Supreme Court judge will be removed. Yes, again, George raising important things here. Why? It is so that the ECI remains independent, because otherwise the highest removal policy, the most intricate removal policy is for the Supreme Court judge, right? Supreme Court judge, and that ensures a transparency, that ensures an independence, and that is the same thing they want to ensure for the Chief Election Commissioner, because again, both very independent bodies, and the removal ground should also remain very strict and stringent, which is why the correct answer was in the manners for the Supreme Court judge. Next question. The UPSC is obligated to submit its annual report to whom among the following? Is it the Chief Justice of India? Is it the Prime Minister? Is it the Council of Ministers, or is it the President? So who needs to see the annual report of the UPSC? Your timer has begun. We are guessing president, 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 and we are correct. The president. And what is here? President who tables on parliament. Yes, president then has to report it in front of the parliament. Excellent, George. And 323(1) is what states this, that it shall be the duty of the Union Commission to present annually to the President a report of the Commission, and then the President states it forward before the Parliament. Next question. What was the 122nd Amendment Bill to the Indian Constitution about? Was it about the introduction of goods and service tax, the GST? Was it about the Panchayati Raj system? Was it about the introduction of the right to education into the Indian Constitution, or was it about both GST and the right to education? What was it about? Guesses, guys? The timer has started. Why are we not beating the timer? Pile, Philip. Yes, GST. Very good. It was about the introduction of GST. It was in 2016, and it also provided for the creation of what is known as the GST Council. Next question. Which of the following is considered to be a community welfare provision? A community welfare provision of the Constitution of India. Is it Article 40? Is it Article 41? Is it Article 42? Or is it Article 43? The timer is here. A community welfare. Think of the contents quickly. We think it's 40. We are correct. Why? Why is it 40? Because we are trying to establish a grassroots democracy, and that is enabling community welfare from the Gandhiji's quote that we have to bring democracy to the footsteps, to the doors of people. Gandhian principle. Excellent. George, our minds are sinking today. Excellent job. So the welfare provisions, the intent is to promote grassroots democracy, to take it to the doorsteps of people. So it is a community welfare provision. It is a very holistic intention that we have in Article 40 to represent people from the very, the tiniest bricks of society. 94th question. Only 6 more questions to go. We can do this. Can a written letter by a convict to one of the judges of the Supreme Court be treated as a writ petition? Yes, no. Does it only happen on the discretion of the president, or does it only happen when the prime minister allows so? Just like the earlier question we had, with a small twist. We didn't have the convict portion over there. We only had can a written letter. Excellent. Yes, it is one. But what we had in the earlier question, I added it to confuse you. I didn't write convict in the earlier question. It was the question just went, can a written letter be treated as a writ petition before the Supreme Court? This is a convict. And I was just trying to emphasize the fact that a convict did it from the confines of a prison. He wrote a letter and it was sent to the Supreme Court and treated as a writ petition. So yes, it will be, even if he is a convict, or otherwise the writ petition can become can emanate from a written letter. 95. Fundamental duties, when were they added to the Constitution? By which amendment? Were they added by the 24th Amendment Act, the 44th Amendment Act, by 42nd Amendment Act, the Constituent Assembly itself? George has added on to our earlier question. Yes, D. Basu was not a convict, but yet he could do so, which says that writ petition by convicts or non-convicts will be treated, whether they are written letters. We've had clippings go in as PILs as well. So the approach is made easy. It is the 42nd Amendment, right? It was not in the Constitution from the beginning. Fundamental duties. What was key here was the workings of the Swaran Singh Committee that the government constituted in early 1976, and then the duties were added. With reference to the Constitution of India, which of the following pairs is not correctly matched? Forests belonging in concurrent list, public health belonging in state list, post office saving banks belonging in union list, or stock exchange belonging in concurrent list. Your timer starts now. What is incorrectly matched? What is wrongfully matched? No guesses. It is the stock exchange and concurrent list, guys. Stock exchange and future markets are within entry 48 of the union list. Okay, in the seventh schedule. So stock exchange, things like these belong to the union list, not the concurrent list. Think about it. Stock exchange, very important, a matter of central importance, governs the entire country, cannot be shared with the state, has to remain with the union. Next question. We are nearing the last questions, guys. The president's rule under Article 356 remains valid in the state for a period of how long? Is it for 1 year? Is it for 2 years? Is it for 9 months? Or is it for 6 months? What is the magic figure here? How long does it remain? It remains for 6 months. Shubham, no, 6 months, not 3 months, not anything else. Monica, 6 months. 356.4, a proclamation approved via this 365th article, unless revoked, shall cease to operate on the expiration of a period of 6 months from the date of issue of such proclamation. So 6 months it will actively remain. 98. The power of declaring any community as scheduled caste or scheduled tribe is with Parliament, or is it with the Home Minister? Is it with the President of India, or is it with the Chairman of Supreme of Scheduled Caste or Scheduled Tribe Commission? Who is the power with of declaring a community as an ST community or as an SC community? We are right, it is with the President of India. 341 and 342 entail that the President is empowered to declare, with respect to states or union territories, any class of people as any caste, any race, any tribe, or any tribal community to be a scheduled caste. And then 342 talks about the same thing, but with respect to scheduled tribes. Next question, second last question, guys. Let's keep it going. Let's know how many of us are here. Let's keep it really good tab on what we got wrong, what we got right. Which concept refers to the division of powers between the union and the states in India? The division of powers. Is it the concept of federalism, parliamentary sovereignty, judicial review, or separation of powers? Federalism, or is it the separation of powers? It is federalism. We are right. That was there just to confuse us. Federalism reads as the division of powers. Separation of powers is the creation of different institutions so that powers are not confined and concentrated and centralized. Federalism refers to the division of powers between the union and the state so that they can function harmoniously. There is a distribution with respect to the executive, there is a distribution with respect to the financial aspects, and there is a distribution with respect to the legislative functions. George says separation of power is in legislature, executive, and judiciary difference. All right, let's move on. This is the last question, guys. Last question. Who among the following may by order suspend the right of a citizen? The right of a citizen to do what? To move the Supreme Court for the enforcement of part of fundamental rights once the proclamation of emergency is made. So, who may order the suspension of a right of a citizen to move the Supreme Court, Article 32, for the enforcement of part of fundamental rights? Is it the Prime Minister, the President, the Speaker of Lok Sabha, or the CJI? Who has the power to do so? We think it's the President. We think it's the president, and we are right. It is the president. So what is relevant here? Article 359 is relevant here, where a proclamation of emergency is in operation. The president, by order, is able to declare that someone's right to Article 32, moving the Supreme Court, is under temporary suspension. But again, this does not happen for Articles 20 and 21. You always have resort to Articles 20 and 21. And not just your right to move the Supreme Court is suspended, is subject to suspension by the president. If there is a proceeding pending in a court for the enforcement of anything other than Article 20 and 21, that can also be subject to suspension for a while. So how do we feel? How much do we feel? How prepared do we feel? That was a long while with many questions. We have discussed 100 questions. That is not a small deal. That's a great feat for us all here. We have gone through, we have walked through, not just walked, we have jogged through with all of us here. The speed we had was amazing. We have jogged through 100 good questions. So what was the consensus so far? How many questions have we gotten right? How many confusions have you walked into, and how many confusions will you work on clearing in your mind? How many questions did you realize that you were thinking about wrongly? So how much clarity did you gain? That is all I care for. Can I get to know in the comments how it went? How many confusions did the question spark? Because that will prompt you to go back to the provisions, find out what you were thinking wrong, what you were understanding and interpreting wrong, and correcting it. Come on, guys. Let me see some tallies and scores. I'm waiting in the chat. Yes, of course, Pratibha. You can, once the live ends, it will be available again. Shubham only got 10 questions wrong and has one confusion. Shubham, again, just reach out to me on WhatsApp chat. Confusion regarding Article 51, reach out. Excellent, guys. Shakteja, you got confusions. I hope you have marked the questions right there. I hope you have marked them right there, and you can go back to the provisions and make sure you do not face the same confusions in the prelims. All I want is for all of your confusions to come out right now and for us to clear them so that we don't see them in the prelims. And you go into the prelims with absolute clarity on what is the correct answer, and you just zoom through the questions and finish the paper. So, well done, everyone. Excellent work. You stayed with us for 100 questions, and I hope you carry this strength and this josh, and you actually hashtag Jeetlo Judiciary, and we see most of you here over there. Yes, ma'am, improvisation is all. I will have to focus. Yes, guys, I hope I see you all on the other end, on the other side. Let's aim for more correct answers in the next quiz. I'll see you in a few quizzes. We'll have other people deliberating on the quizzes, amazing faculties helping you out, my colleagues and my workmates helping you out in the next few quizzes. And I hope you just keep getting correct answers and correct answers. And when I see you next, I hope all of us here to have more questions, correct answers under their belt. So let's see you at the next few quizzes. And that was all for today. Have a good night, and please be very diligent with your mock attempts. You have another mock paper shortly. Refer to your schedules, and you can also go back in the DJS prelims group on WhatsApp, where you will find all the required details. So make sure you're turning up for your mocks. Make sure you're going through your marathons, your quizzes. If you miss any part of the quiz, make sure you are referring back to the video, and the video stays here. You don't have to worry. The mocks stay on the portal. The video stays here, and it is all here to help you. And let's go. Let's Jeetle Judiciary. Thank you, guys. Thank you, guys. We'll see you in the next live session, in the next quiz. Take care. I hope you rest well before your mock paper next. Thank you. Bye.